Good afternoon and welcome to this policy dialogue on the rule of law in the EU in cooperation with the Connecting Europe project. I am Eric Maurice, a policy analyst here at the EPC, and I am happy to have you online. Last week, the European Commission published its sixth annual report on the rule of law, where it examines the situation of the rule of law in the 27 member states, but also in 4 enlargement countries, Albania, Montenegro, North Macedonia, and Serbia. It also makes recommendations to improve the state of the justice system, anti-corruption, and other issues in which we will go into. This report covers 4 key areas: justice, anti-corruption, media freedom, institutional checks and balances. And for the first time this year, it also integrated a single market dimension to the analysis of these 4 areas. And of course, we will see exactly what this means. The European Commission was quite positive in the report, looking at the progress made, but also it acknowledged that the situation is not improving in a number of EU countries, and that's what we will look at more specifically. How can the EU address the challenges to the rule of law, the challenges that continue? Is the rule of law toolbox fit for this purpose? Should it be strengthened, and how should it be strengthened? And also today, the Commission will present the new proposal for the next EU budget for the next years. How rule of law will it be important in this MFF? How conditionality will play a role into strengthening the rule of law in the member states and across the at EU level? That's what we will discuss with our 4 guest speakers today. First of all, Daniel Freund, you are an MEP. Good afternoon, and thanks for being here on this very busy day in the Parliament. You are part of the Greens EFA group in the Parliament, and also you are a shadow rapporteur for the rule of law report, so you know very well this topic. We also have with us Florian Geyer, head of unit at the rule of law unit in the European Commission. So you are the man to explain to us what exactly is in this report and what could be done after. We also have online Márta Pardavi. You are co-chair of the Hungarian Helsinki committee. And last but not least, Maria Skóra, you are a policy fellow at Das Progressive Zentrum and also a reconstitution visiting fellow at the European Policy Center, or you were, because you left us unfortunately just a few weeks ago, but you did not leave without publishing a piece on the rule of law, which is called "What Future for Rule of Law Protection Towards a More Effective Use of the EU's Toolbox under the VDL 2.0 Commission." And we will post in the chat of this event the link to your piece, and also you will be able to summarize your findings. Speaking of the chat, of course, our audience today is very much welcome to ask questions in this Q&A, in the Q&A box at the bottom of the screen, and I will take the questions and distribute them with our speakers. We have 1 hour, so I hope we will have enough time to go around this issue, and I will start with maybe the man who held the pen of the report, Florian Geyer from the European Commission. And I will ask you a very simple question. What are the main findings of this 2025 rule of law report? And a subsidiary question, what does it say about the new Commission's priorities for the EU? And also, please tell us more about the single market dimension, which maybe not very clear to our audience. So please, the floor is yours.
Thank you so much for the opportunity to have a first. In a way, this is the week after the publication of the report. I think you start more or less the circle, in which we present also in the think tanks, in various conferences, our work, the rule of law report, and by this also make it more known and actually also attract more attention to the content of the report. Because what we don't want to do, and this is a very important message also that we repeat in every instance, that this report would be a report for the drawer or for the library, and we work for 1 year. We have, like as Commissioner McGrath also said in the press conference, over 270 stakeholder contributions. We had over 650 meetings. We met around over 980 national authorities, ministries, courts, independent associations, civil society organizations, and others, only then to write around 800 pages, presented on 1 day in July, in the middle of summer, as some accuse us, and then it disappears for another year. This is exactly what we don't want to have with this report. This is why we have the recommendations also in. This is why the report is the basis for discussions among the ministers in the General Affairs Council. This is why it's being the basis for discussions in the European Parliament, in LIBE, in the RFMG, but also in other committees like in the CONT committee. So it has, we hope that it has a very wide outreach and can serve to stimulate then also the national debates, and add this European dimension to the reforms. Very briefly, again, as part of the introduction, we were, for instance, very happy to see that in Austria, one of the recommendations that we had issued for a couple of years on the federal prosecutor, the independence of the federal prosecutor. So 1 day after our report, the Austrian government presented an initiative to reform the federal prosecutor and to get rid of the instructions that the Minister of Justice can give into ongoing investigations. This is an issue that we have been flagging in the rule of law report for a while. It's one issue among, of course, many, but to see, and this is of course not directly linked one day to another, but it is something that we really want to create with the report, is to stimulate these reforms, to accompany them, and to add this additional dimension. So this year's report, as you said, it's the 6th report, confirms in our view that this positive trajectory in many member states. It's important reforms have been taken forward across the 4 key areas that you mentioned: justice, anti-corruption, media freedom, institutional checks and balances. Of course, challenges remain in some member states, and in a few cases the situation is serious, but the overall engagement with the process by the member states, by civil society, remains strong. Member states have addressed a substantial number of the 2024 recommendations, some in full, some in part, but this is also due to the annual cycle that we don't want to change. So we want to keep on reporting annually. Some people say you need to give more time, you need to do it every 2 years, this report, it's too much work, but that would mean, that we lose a bit of the dynamic, of the traction that we have by doing it year on year. But that also then means that not every reform can be achieved in a year's time. Constitutional reforms, for instance, majorities, elections happening, governments fall. All this has an impact on the ability of member states to act, to implement reforms, and this is why sometimes it takes longer than 12 months, essentially. Respect for the rule of law is essential. This comes to the single market dimension. It's essential for delivering policies that promote competitiveness through the single market and empower citizens to actively participate in both society and the economy. And here the rule of law is an important consideration for companies operating across borders. What we have been looking here in particular are instances like stable and predictable economic environments, and that entails issues like sound lawmaking, public procurement rules, the stability of the regulatory environment, the possibility to impact in ongoing legislative processes, the absence of ad hoc legislation or riders, like legislation being added on to completely unrelated reforms that could have an economic impact and create this instability in the business environment. These were the aspects that we were looking into among many others. And then, as you say, what are the what is the priority and the outlook. I think here, and you mentioned it already before, this comes at the moment where we evolve, where the Union evolves. The new generation of EU spending instruments will be presented publicly later today. As Daniel Freund mentioned, they are already currently being presented to members of parliament, but later today will be a press conference. And this new MFF, the Commission intends, and we will see how the negotiations then go with Council and Parliament, aims to ensure that the compliance with principles of the rule of law remain a must for EU funds. EU financial support for investment and reforms to promote the rule of law can, in our view, offer a real added value. And we want to have this element as a broader effort to track the effective implementation of the recommendations that we issue in the report. So there will be a much stronger link between our rule of law report recommendations and this financial support. And I think everyone is very excited to see later today how this will pan out in practice. I leave it here not to talk too long, and I'm happy to discuss further.
Thank you. Indeed, we are all impatient to see what is being proposed. I will turn now to Márta. The Hungarian Helsinki Committee is one of the sources of the report. You've been maybe yourself being interviewed. So what does this report represent for an organization like yours? And do you think, because you are based in Budapest, do you think this report addresses the current challenges in Hungary and across the EU, the challenges to the rule of law? So very simply, are you satisfied with the report and what it says?
Thank you very much, and greetings to everybody from Budapest. Indeed, the Hungarian Helsinki Committee is one of 8 Hungarian NGOs. We've been collaborating on a regular basis to prepare our own input in the stakeholder contribution. And I have to say, this is something that we are gearing up when we put together our annual work plan every year, knowing this requires immense effort, usually at the time of the year when there's other competing priorities. Both when we write our inputs, usually over the Christmas holidays, but also now in the middle of summer. It's not every year that we would be all glued to our computers looking for how rule of law will be linked in the MFF to various funding programs. So it is a big effort. And I'm happy to see, as I always every year check how many other stakeholder contributions were received by the Commission, that the number is growing. It is not growing exponentially, but it is certainly growing. And every year we also not only work on the contribution ourselves, which runs to many, many pages, but also encourage other civil society organizations, human rights defending organizations around Europe to contribute themselves. And I've seen more and more of our partners do so. But when we are convincing others, I have to say that it's not only the investment of their time that is a question that comes up regularly, but also what is the so what, right? And I am also, I want to say, very, enthusiastically, curiously going to follow the press conference later today to discover what is the so what. From the first year when this report was published, it focused more on, I think, identifying issues. Now we've moved to also seeing recommendations. But the so what actually comes after the recommendations, as we've seen over the years. And this is something that is particularly, I think, relevant for Hungary, where we've seen that the report itself is a good tool to diagnose problems and issue recommendations. But what happens to this really depends normally on domestic, political, and legislative will. But in Hungary's case, it depends also on the will, the actions, the competence of other institutions, such as the Commission and member states. So there's always so much more that follows from what the report has been doing. And this was particularly true in 2025 when we read the recommendations. They're basically a repetition of the recommendations from last year. While there is a number of recommendations that for other member states recognizes some progress, and in some cases, quite exceptionally, I think, full progress, there is no such thing in Hungary. And this is, as a Hungarian, of course, very, very painful to see. It seems that there is no political dialogue even on the substance of these issues in Hungary. And so for us, the reason why we invest is because we want to provide an evidence base based on facts, based on myriads of footnotes leading to other documents that will help an objective assessment of what is going on. And so the question is whether this is reflected in the report. And I have to say that the recommendations echo our own concerns and recommendations, but we do have some differences. For example, if you read the Hungarian report, I think it is clear that there is something really, really wrong in Hungary, and the single market dimension absolutely highlights this. In fact, I really welcome the single market dimension because in the Hungarian case, it certainly highlights the end to the rule of law erosion, which is the means. And so we see such strong language in the single market dimension, which perhaps was not available in this way from the Commission to the public yet. Of course, there was tons of discussions about it in conferences, perhaps in industry events, but from the European Commission, this is a summary that encapsulates why there is rule of law erosion in Hungary and why is corruption not being tackled. But at the same time, this comes a little bit, I don't want to say at the expense, but it does come with perhaps a balancing effort or a trade-off that the classics of rule of law fields, judiciary, media freedom, and also checks and balances and the implementation of court judgments is not as strong perhaps as it used to be. And I think this is reflected in the recommendations. So some of the specificities that are quite important because this will help the follow-up action, whether in new instruments or existing instruments, is going to be more difficult. So, for example, not seeing that the Court of Justice had to issue financial penalties to the government of Hungary over the non-implementation of a judgment on in the field of asylum last year. It's missing from the report, and I think this is quite significant. In fact, it's quite a significant topic, even in Hungary itself. Another thing that we thought could be perhaps brought out more is not only the erosion of judicial independence and the lack of real measures to build it back, but the very, very strong resistance from Hungarian judges themselves. So I remember on a late February, I myself participated in a relatively big demonstration, which was organized by judges associations themselves, who questioned the deal that the Hungarian government basically forced on them in exchange for pay rises. So these are the kind of details that don't come out as strongly as they could, while the single market dimension, I think, will be very, very important and will also allow perhaps for the Commission to take follow-up action in the field of competition law.
Thanks, Márta,
Thank
for this very concrete perspective. Let's have now a more political view on the report. And of course, I will turn to Daniel Freund. As I mentioned, you were a shadow rapporteur for the 2024 report. So in the light of the report, which was adopted a few weeks ago at the last plenary, I think it was, what is your first reaction, or first a week after, what is your reaction to this year's report in the light of what your experience, what you've followed in the last few years, and of course on your report, or the Parliament's report on the last year Commission's report? Is it going into the right direction? Also, if we look from the first one to this one, how are you seeing improvements, or is it still disappointing from your point of view?
Well, thanks, Eric, for having me, and that we have this conversation on the rule of law report. I have been following the previous issues of this report since its inception, and when I was also first elected to the European Parliament in 2019. I mean, if you look at the overall situation, the state of the rule of law, and you compare, when this all started 6 years ago and where we're now, I would say, and I think the report also adequately reflects that, is that the state of the rule of law in the European Union has not gotten better. I think that we have the report is immensely important, and Mr. Geyer and also the Commissioner have pointed to some improvements in some member states that have followed recommendations. We see that the rate at which member states actually do something about the recommendations slightly goes down, and we can, argue about the details of that. But I think none of this can hide that if you look at the tremendous rule of law crisis that we have in Hungary, there was one 6 years ago, but it has gotten worse. And if you look in a number of other member states, and I would maybe name Slovakia first and foremost, where we have just issued 2 mission reports from the Budget Control Committee and also the Libe Committee that have both been, and I was member of both those missions to Slovakia, where we see a sharp decline in rule of law, in the fight against corruption, on media freedom, and so on. So there is a real crisis, and it's of course vital, that we have a detailed picture of what's going on. It's also important that we issue recommendations to the member states, but we must not stop there. It cannot just be that there is a monitoring and a reporting on the attacks of the rule of law and the decline. We also really need to do something about that. And in the case of Hungary, for example, there is some action. There are some infringement procedures. There is still 18 billion euros of funding frozen. But none of this has halted the attacks. If you just look, for example, on the freedom of assembly, the right to demonstrate, what has happened around the Pride in the last few months, that the right to assembly, the freedom of assembly was severely curtailed in March with legislative and constitutional changes in Hungary, then actual requests for demonstration were prohibited. We now have, just in these last few days, we have the prohibition of certain demonstrations, not even on the topic of LGBTIQ rights, but if the organizer is an LGBTIQ person, they are not allowed to register demonstrations in Hungary. And still, I have the impression, I hear from the Commissioner McGrath, they stand ready, they monitor, but it's time to take action. It's no longer the time to just look and see how much worse is it going to get next week. It's time to really do something about this. The way that the rule of law is under attack in some member states, it's unfathomable. And so as much as I appreciate the work that Mr. Geyer, his colleagues, and also the civil society, Márta, and others that contribute to this is, and how important it is to provide an evidence base for us political decision makers. But the evidence base on some of these attacks we've had for years, and it's time to act on these and not just wait for the next issue of the rule of law report and see that it has gotten even worse.
Thank you. Well, the question you raise is the one about the new challenges to the rule of law, or the new forms of violations of it, but we'll come to that later in this discussion. But Márta alluded to the so what question. So I will ask Maria, as an expert who wrote recently, how do you put the report into the EU toolbox on the rule of law? How much teeth does it have? Is it something that is really important to, well, first to look at the situation, but also to act? And in your view, what should be done with this report, or more generally with the toolbox on the rule of law?
Thank you so much, Eric, and thank you for invitation to discuss in such a great company today about this topic. Well, I will perhaps start with the 2025 edition of the Rule of Law report with these key developments. I would briefly like to talk about them because I think they shed some light on the new approach or new ways of how to tackle the rule of law and a single market dimension. I find it a very relevant development and a sort of opening new pathways for tackling the rule of law erosion. And why? Because it sort of tries to do what many people have been advocating for, many experts, to show why the rule of law is relevant, why is it important, to making the rule of law tangible, explaining its impact on life, and I think explaining or showing its impact on the economies, economic activity, on the stakeholders which have pretty vested interests in a good functioning state, good functioning judiciary, and pretty powerful stakeholders, because private sector is a powerful stakeholder with capital, lobbying instruments, and so on. Perhaps could increase this corporate democratic responsibility, if you want to put it this way, to exercise also pressure on governments from that side to uphold the rule of law. Maybe it's naive, maybe it's still a very optimistic point of view. This responsibility of a corporate sector attitude is, of course, ambivalent. But I find it a very good development. And here I'd like to highlight the work of my colleague Jörg Albrecht from the Institute for Europäische Politik in Berlin, who has been pointing at it for the last few years, taking, of course, Hungary as a case study, how important it would be to also advance defensive democracy, defense of the rule of law from this point of view. So it also brings some meaning to the work you're doing as a think tanker. So please check out also his publications. And then the other issue is the commitment to protect the rule of law through protecting the budget. And this is, of course, conditionality, not only the general regime on conditionality, but I think here it is a thought broader as financial conditionality or negative conditionality. So applying freezing funds as a sanction for rule of law breaches, but also in positive conditionality, the incentives to actually incentivize reforming the rule of law and changing and improving how it works. So this edition of the Rule of Law report highlights these two areas as key developments, and in my view, they are to be much welcomed. So this is the positive that I wanted to start with. Well, the impact of the Rule of Law report, well, as it was said, it is a monitoring, a reporting tool. And of course, not a tool, as Florian Geyer said, to be put in a library and just sit there just for interested parties to report. And their recommendations are actually the key evidence for continued dialogue, be it in with the member states or in the General Affairs Council, in the European Parliament, also in consultative committees, to continue those, let's put it this way, soft diplomatic measures, exercising pressure and on countries, member states that perhaps lag behind in certain areas. And it definitely is a source of information, and already by hearings of both Commissioner for Budget, but especially the Rule of Law Commissioner, it was highlighted that perhaps this causal link between the Rule of Law report and potential sanctions or actions by the Commission, for example, applying the general regime of the conditionality, should be more in sync. The findings of the Rule of Law report should really serve the purpose of the what then. So as Márta was highlighting. So what about it? But to get finally to your question, Eric, about the report and what could be improved, how its functionality could be improved. Well, it is a tool of monitoring, so looking at the continuity of tendencies, changes over time. And in that sense, it fulfills its purpose, fulfills its functionality. It's a very rigid and regular record of the developments in the EU, of improvements, but also deterioration. And as such, I think we should do some expectations management, because the next steps from the Rule of Law report are somewhere else. And here I would really welcome this signals sent by the current European Commission of sticking to the conditionality and making it a more standard practice. As we've seen, the soft dialogical measures, tools, have not brought much results. The problem, I think, is not what to do with the rule of law reports, but what to do with its recommendations, and especially when the recommendations are not met. And then let's also think about how they land in different member states, because there are member states, and my colleagues have already mentioned it, in which the problems with rule of law problems are orchestrated, are deliberate. There's not only lack of political will to improve something, there's actually political will to destroy something. And we should rather think what to do to address such circumstances. So more decisiveness and with corrective measures, linking it very clearly to rule of law breaches would be necessary, but also consequence, but also deterrence. Perhaps this long-term monitoring, if connected with sanction, could also not only serve the purpose of reporting the developments over the rule of law, not only correcting them, but also preventing rule of law in erosion in the future, because in the end, this is what we want to have. We don't want to have rule of law problems in the European Union.
Thanks, Maria. We had the first questions from the audience, so I will start taking them. And speaking of the devil, Jörg Albrecht, he has questions for all of you. But first, I will take, and it's nice to have him in this event. In the audience. I will first take another question, which I will ask first to Daniel Freund and then to Florian Geyer, because I think they will have complementary answers about the fact that it is encouraging that the Commission includes this new single market dimension, but what about the issues pertaining to fundamental rights? And I know that it's been something that has been raised many times by the Parliament. So why it is not in the rule of law report? Maybe you have an answer, Florian Geyer from the Commission, and then Daniel Freund. Is it something that the Parliament will continue again ask to include into the report? So Florian first.
Okay, thank you. Indeed, this is one of the long-standing demands also from the Parliament. Also, just to mention briefly, before so on the 18th of June, I think it was, that the Parliament adopted the resolution on our last year's report, 2024, very detailed and rich resolution that also raised a number of other issues where the Parliament thinks the rule of law report should be improved. On the issue of fundamental rights, the Commission's line has been consistent and the same so far. So we do cover certain fundamental rights in the rule of law report. You cannot talk about media freedom, media pluralism without having the right to freedom of information as the underlying thing, as the underlying issue. Judicial, the justice system without the right to an effective remedy. Article 47 of the Charter makes no sense in discussing. All the principles that we apply, that we check, there are expressions of the right to an effective judicial remedy under Article 47 and Article 19 of the Treaty on the Functioning on the European Union. Also, certain aspects that we cover under Pillar 4 are of course fundamental rights related, but it is totally true that we don't look as such into systemic violations of fundamental rights based on individual issues, individual complaints, or individual violations of fundamental rights raised. This is an issue that we still consider to be the right approach, not to do it, because it would also make the report even bigger, even more complicated, even denser in terms of length and in terms of issues to be covered. But I fully take that this is a point for discussion, and Daniel Freund will certainly say that this is a major gap in the report. But this is the political decision as for the scope that we have it now, and we have not changed that political scope yet.
Thanks. Daniel Freund, please.
Not that much to add. I mean, we have pointed this out in the past. We will continue, I think, pointing this out. I mean, one thing that I found curious when you read sort of particularly the assessment on the recommendations from the Commission. And for Hungary, you read time and again that there is no progress. What doesn't come out there, of course, is not only is there no progress, but there is actually further decline, further regress, if you want, of the situation. And yeah, the commissioner spoke about that during the press conference and stuff. But for someone that just naively opens the report and looks at, you know, how is a country performing, and also over time, you know, standstill is not the assessment that I would have had looking at how the situation in certain countries evolves. But of course, if you look merely at the recommendations and whether they have been implemented or not, then that's the situation. One final comment I want to make on sort of, because also Maria spoke about the rule of law toolbox, right? And one of my criticisms of the Commission approach has been that I still have the impression that there are too many sort of silos. There are different parts of the Commission that analyze different aspects on what on the other side is very centralized. You know, I mean, Orban has amassed an incredible amount of power that is centrally controlled, and where he very strategically sort of plays with us. Sometimes, you know, doing some scam reforms to get some money unfrozen, or to get something moving, but then on the other hand, you know, doing the next attack, trying to distract us from what he's actually doing, stealing billions of our money. And I think that in the Commission, the approach is not strategic and you know, centrally planned enough. You know, when we have a situation, and even if you know, with much goodwill, read the report and see that there is no progress whatsoever, and then additional sections, as Márta said, on the single market, you know, very worrying situations. And then out of all the money that we have managed to freeze, Orban now very sneakily has moved 600 million from frozen budget lines into unfrozen budget lines. And the Commission just lets it happen and greenlights that. How is this possible? How can that be? I mean, those are questions that I simply, you know, I don't get any satisfying answers to, I have to say.
Does anyone want to try to answer? Okay, I will take other questions then, because we have a few. One from Maria and Márta about the interlinkages between the rule of law and other initiatives such as the upcoming Democracy Shield or civil society strategy. And I will start with Márta, of course, with the civil society link. So what can you say?
Well, I absolutely see a lot of interlinkages or potentials for this. The Commission has highlighted in every report and in the original communications related to the rule of law reports as such, is that civil society is an actor of the rule of law. And so it is very obvious to me that this ability of civil society to fulfill this function should be something that is both protected and promoted, encouraged in other strategies and other policy areas. So it's not only that, you know, 8 organizations in Budapest stick their heads together in December and start doing 70 pages of input. It is because we feel that this is an important instrument, but I have to highlight that we also are very aware that there is a cost to this, not only in terms of the hours that staff spend on this, but also in terms of the attacks that we will then inevitably sustain. All of the organizations who contribute in this joint report to the Commission's stakeholder contribution are coming under pressure every year, all the time, from Hungarian smear media or from the Sovereignty Protection Office itself. I have to say that two civic actors who are participating in anti-corruption roundtables, and this is something that is picked up in the annual report, have been specifically targeted consistently by the Sovereignty Protection Office. So standing up for the rule of law, as we all know, does come at a price. And organizations need to be able to still go ahead and say yes to this exercise the next year. So we need, in the civil society strategy, funding, funding for protection measures, for promotion measures, but also legal actions. And this is where I want to echo the point made by Daniel Freund earlier, is that the Commission, of course, highlights the problems, but it has quite a lot of tools, legal action, that it can then leverage to protect civil society actors now, before the civil society strategy pulls all the available protection, response, and promotion measures together. So, for example, yes, it is my colleague who is not able to organize a demonstration to celebrate the Fundamental Rights Charter in Hungary because he's a gay person, and Hungary's highest court has also found this to be lawful. So what can we do when the freedom of peaceful assembly is denied to people within the European Union? Of course, we can report on this and identify the problems, but we have to take legal action too. So, for example, responding with interim measures in ongoing court proceedings or launching new infringement procedures should be part and parcel of also the civil society strategy. But even without that, we already have this. The other thing that I think is very important is to allow civil society to do its job by helping it promote these very important rights that we want to actually shield from malign interference. And this can be by, and I hope that the proposal being unveiled now for the MFF will reflect this, and this can be by continuing EU funding directly from the Commission for the purpose of democracy, rule of law, and also civil society's own actions. And this is going to be undoubtedly a target of heated political actions. And we have to be very mindful of why that undermining will take place, exactly to weaken the rule of law, exactly to weaken our awareness and our response to its erosion. Thank you.
Thanks. Maria, I will give you the floor if you want to answer the original question, but I will start with Daniel Freund and Florian Geyer, who have follow-up on what Márta just said. Thanks, Maria.
I mean, just very quickly, I wanted to underline what Márta said on the attacks on civil society, right? And I think the input that civil society organizations like the Helsinki Committee provide to this report are vital, but particularly these organizations that contribute to this kind of reporting are under attack. The cutting of USAID funding is having an impact, particularly in Central and Eastern Europe. And then, we see it in Brussels now as well, that the same smear attacks on NGOs that we had seen, for example, in the United States are coming to Brussels as well, where it's put into question, should civil society get any funding from the EU or governments? Should they be allowed, if they get such funding, to be able to interact, for example, with members of the European Parliament? I mean, not only the extreme right, but even parts of the conservatives, the EPP here in the Parliament, putting that into question. And that makes exercises like the rule of law report and in general the protection of fundamental rights, the independence of judiciary, media freedom, and so on, incredibly more difficult when we have these attacks.
Florian, yes, please.
Yes, thank you. I think this is a very important point. So the funding that we have so far under the SURF program, as you both mentioned, Márta and Daniel, I think is a very important one, and we will fighting to continue being able to do this under the new MFF. As I said, we will all see what comes out later today. But indeed, this funding, also via the umbrella funding that can then spread down further to smaller operators that might not have the capacity to manage complicated EU funds, this is something that I think we're very happy to see implemented in this last period, and many of the civil society organizations that contribute to the rule of law report are also benefiting from CERF funding. And then at the same time, as Freund mentioned, it is exactly this type of program that is coming under attack. The fact that the Commission is funding through CERF civil society organizations is suddenly something that is very bad, and this is something that also surprises us and me, because we're always attacked that we don't help civil society enough. Now, like one of the good innovations, the CERF, is something that is seen as a problem. So this is certainly something that is worrying, and where we nevertheless need to keep our course and have the financial means also in the future MFF to continue doing this work. In terms of protecting, and there very briefly also most likely to something that Maria will mention on the teeth and the actions. I think personally I would be the last one that would not like to see, like sometimes a bit more quicker and stronger action from us as an institution. But I do not want that we underestimate the impact that this dialogue that is sometimes a bit negated, like Geyer, you have your dialogue and you do your reporting, but this doesn't lead to anything. Just to underline, especially in the Hungarian case, the public law, the draft law on the public transparency, the transparency in public life, which would have been or still is a major threat to the civil society framework and organizations in Hungary. The Sovereignty Protection Office, everything that you mentioned, was to be adopted, in June this year, and yet it was postponed to the autumn. Was it postponed because there were clear statements from, I think, very many actors at the EU level, but also internationally? Was it postponed because of the letter that also came from the Commission to say this is a major problem for everything that would be covered in this draft law? But it was postponed. So this is an effect of non-formal infringement action. It's of dialogue, if you call it a dialogue, but this is reported in the report, very long. And it is something that should not be looked over. Similarly, the constitutional amendments in Slovakia, which were supposed to be adopted in second reading a couple of weeks ago, which have equally been postponed after a dialogue interventions that lasted from January, actually, this year. Doesn't mean that the problem is solved. It doesn't mean that that we need not to remain vigilant, but it could be seen as examples of instances in which collective and determined action, even below the level of launching an infringement, asking for interim measures, had at least a temporary effect of preventing things from worsening and being adopted. And retroactively correcting it is always much more difficult, even if it's in a legal and formal procedure, than trying to work ahead of it. And that's also the purpose of the rule of law report, and the fact that we report on this will densen the examples in which we can act, because we have done this already, and it's something that we can rely on also as precedents. Thank you.
So Maria, you have many things to add now.
I'll try to be quick.
Probably you have 10 minutes left.
Yes, I know. So I'll be very quick and refer quickly to the initial question about democracy versus rule of law, or together, rather. And I think we see a sort of a crystallizing approach towards both, or strengthening both, or preventing breaches of both at the European level. And I would say that I think regarding rule of law breaches, they are rather, or the expectation is that they will be rather strengthened via these financial measures. So penalties, conditionality, withholding other funds, and such techno-managerial instruments like reviews and monitoring. Whereas democracy, we see that there's a sort of a different approach, a combination of strategies, non-legislative initiatives, like indeed the democracy shield, dedicated funding like the aforementioned SERV, but also relevant pieces of legislation like regarding the Media Freedom Act or the digital sphere. So for a good reason, the new commission does have a democracy rule of law commissioner, and also democracy is also included in the digital portfolio, looking at the hybrid threats that we are all facing, and the rule of law is also part of the portfolio of the budget commissioner. So Daniel Freund was already talking about it, how we need centralization or coordination to feed all those strategies, to help them work together and achieve goals. And I think these foci are correct in that sense, that of course rule of law breaches are eroding a democratic system, but also strong pillars of a democratic system, including the media, including civil society, of which we have already been speaking today, help to strengthen the rule of law resilience. This was also a project that Jörg and I worked on for a few years, not that long ago. And these dual strategy and diverse measures, long-term, short-term, using sticks and carrots, let's put it this way, should be used to their full potential to face the challenges we're seeing coming from the outside, obviously, but unfortunately from the inside. And these seem to be even more problematic at times.
Thanks. In the last minutes we have, I would like to address the few questions we have on, or the several questions we have on candidate countries. Sorry, there is one on, could the conditionality regime be applicable even before these candidates join the EU? And also a question on, should they be more included into the EU internal rule of law discussions to prevent outdated frameworks from being applied in the enlargement policy? So I know it's not exactly your field, Florian Geyer, but would you have some elements to give us? And I don't know who else would be willing to address this question.
Yeah, no, I think I can do this very briefly. I think, of course, the conditionality regulation as it is at the moment does not apply like to non-EU member states. That's an internal tool, but that doesn't mean that also mainly looking at what comes today, that not in the financing instrument for the external action, there would not be elements of conditionality understood, in a different sense, that we should only be financing, activities that are in line with fundamental rights, rule of law, etc., that they would not also be subject to that. And if money would be used for, like purposes that would run counter, that this could not be also recalled back. So, but this will have to be, as I said, we need to see that in today's also sectoral proposals, as much as they come today, that the second part of all the financial MFF programs will come also in September. So not everything will be today, but indeed this is one of the points for discussion. In terms of bringing in the enlargement countries into, like non-outdated frameworks, that's exactly the point of why we since last year integrated already 4 of the enlargement countries in the rule of law report, to make them acquainted to what it is that they would be participating in once they have joined, whilst not prejudicing, the formal process of the enlargement process, the benchmarks, the chapters, that need to be negotiated and closed. But the standards, the European standards that we apply are the same. So the European standards we apply, like Council of Europe, Venice Commission opinions, Council of Europe recommendations, Court of Human Rights judgments, Court of Justice judgments, international agreed Greco recommendations. So these are the standards that the enlargement countries need to fulfill and cover in the enlargement process. And then again, these are the standards we use in the rule of law report. And the idea is that with the 4 that we have at the moment, new ones who fulfill, like the level of progress of readiness comparable to the 4 that are currently covered for enlargement countries, that they would be gradually included, maybe next year already. to more. This needs to be seen, but this is indeed the ambition that we want to have, so that there is this seamless, like understanding of how does it look once I'm inside, while I'm still with one foot, or many foot outside, but I have already 1 foot in. I think this is an innovative way also of having this bridge, this transparency, because the enlargement countries, they participate also in the meetings with the national contact points. They are consulted in the same way. They have the same methodology that we apply. So this is a very interesting, innovative way of bridging the gap. There's a question from Kati Tsedes, Eric. I don't know if you want me to reply to this on the competitiveness and the single market. This is the one that
yes.
So I think
shortly, please.
Exactly, totally shortly. I think the idea is that when President von der Leyen announced, like the single market dimension last year in the political guidelines, I think it was twofold. On the one hand, I would say it is also to respond to the issues that Daniel Freund was mentioning, that sometimes we feel that there is a dysfunction, a disconnect between different sectors in the Commission. And I think the case of Hungary is a very telling one, because we have received, economic operators complaining about different aspects of EU law. They could be on the field in taxation for retailers, while they could be in the field of, concessions when it comes to earth and sands. So, and it's each time it would be it is a different Commission department that looks into that and sees only the single issue, of an economic operator in one member state without seeing the whole picture. So with the European semester process, where we already worked on this, plus now the rule of law report, we try to bring stronger into focus what are, cumulated aspects that make life of economic operators harder to operate, either in one member state or in the single market. So this to bridge a bit, to bring down those silos that we have indeed seen. And on the other hand, yes, of course, the political priorities is to restore competitiveness and rebuild an economic base that we need at the current time in Europe. And if the rule of law report can contribute in this, absolutely, this is an objective that we are happy to take with us, if it can contribute and help in these aspects. Thank you.
Thank you. So we have 2 minutes left, so I will just make a last round of you, asking you 2 questions, or you can answer only one. What is, according to you, what are the main challenges, or what is the main challenge currently to the rule of law, or what should be the priority in addressing this challenge from the EU, or from the member states also, which also have a role to play? So I will start with you, Maria, then Daniel Freund, Florian, Geyer, and Márta to finish.
A very easy question, obviously, for the very end. No, I would say that the big challenge is, I think, challenging at the discursive level the accusations or the evidence of actually rule of law breaches. And we see governments, in some of the member states, trying to convince not only European institutions, but also their own domestic audiences that the rule of law breaches are not rule of law breaches, that they are a fight for sovereignty. So I think, and also using legal measures to sort of prolong any sort of litigation or process, and clarifying if it is, if it isn't, or if there are sanctions to be put on it or not. So I would say this remains a big challenge. I would call it the politicization of rule of law breaches and how to go about it.
Daniel Freund.
I think the biggest challenge is that there are so many attacks and so broadly in so many member states, right? That it becomes increasingly difficult to see if there is still political will to act. That we still cannot even get a 4/5 majority to act on Article 7 on Hungary. I'm not even talking about unanimous decision or 26 member states decisions. And, we might come, depending on how national elections go, we might come to a situation where we don't even have qualified majority anymore to protect the rule of law in the Union. So I think that is the big challenge at the end. Is the political will there? Will this be further politicized? Will the polarization progress so much that we can no longer have sensible debates about this? When we look at the United States and how the debate there is going on, arresting federal judges, and how in one, or if not the oldest parliamentary modern democracy, the rule of law can be undermined with such speed. I'm worried for how this will evolve in the European Union as well. That's why I'm urging so much, that we intervene, that we don't let countries slide, and that early on, when the attacks, as we see now in Slovakia, that we go in and halt this before it gets too late, as it might be in the case of Hungary.
Okay.
Yeah, I think as well, picking up, I think the global developments in which the law as such is, being put into question is not something that helps us then in fighting for the rule of law. If this basis of understanding is already denied, and if everybody is, or many actors are just too happy to pick on this trend, and then combined with maybe some naive or academic or, whatever considerations, even then inside the strong forces that still defend it, I cannot say how dangerous I find very openly from pro-European forces the narrative that we have no definition of the rule of law at EU level. And you hear this way and time again, even from very high-ranking, politicians. Pro-European forces would say, let's have a seminar on discussing what the rule of law is about, because there is no definition of the rule of law. We have 6 years of rule of law report. We have a definition in the conditionality regulation that sets it out black on white. So we cannot afford at this moment of these global developments to start questioning the progress that we have achieved, or to start going to fundamental aspects that are only then, again, too easily picked up as it's all just politics that is being done on the rule of law report. What is very positive, and this is also coming a bit too short, I think, in our discussions, very briefly, while we do the rule of law report, while we have done, the toolbox, actually we have tools which do not run as toolbox, but which are very, very important, like the Media Freedom Act, which the implementation period ends on the 6th of August. The SLAPS directive, which next year is being enforced and implementable. The whistleblowing directive that we have now for a couple of years, the anti-corruption directive that we are negotiating. That means that aspects that we cover under rule of law report so far as recommendations will, in the media freedom part, be hard law in 1 month's time, and be implementable, enforceable via infringement procedures. So there we have basically a thickening, a densening of European standards into law, into European law, that has so far been mere recommendations in the rule of law report. And this is very important in this time in which many things are being questioned, because it gives other opportunities to seek to enforce elements which were before unenforceable. Thank you.
Thank you. Márta, Pardavi, you have the last word, but unfortunately the shortest one, please.
So agreeing with the importance of political will, yes, it is very easy if you have the political power to break the rule of law, and it is very, very difficult to build it back. We've seen that even if you have political power to some extent. But what is also, I think, very important is that we have actors in society and citizens themselves who feel that this is important to them, that there is a public demand for this. So this requires reinforcement by politicians and also by civil society actors. I think there is a lot more actors in all sorts of sectors out there who need to be coming together in a very practical way to uphold the rule of law. We might seem in this conversation as representing a lot of sectors and countries, but in fact, I think we have a much more diverse society, and not everybody understands still, even in civil society, how fundamental this is to Europe and to the freedoms we enjoy.
Thank you very much to the four of you and to our audience for their questions. We could not address all of them, but thank you very much for them. I wish you a good afternoon, a good summer, and see you for another EPC event. Thank you very much. Goodbye.
Thanks.
Thank you
Bye.
very much.
Thank you very much for having us and joining us.